Thank you for joining us back here today. I hope everybody has been enjoying some of the previous videos. Anyway, some people have been talking to me like, John, maybe this is just North Carolina. Maybe most of the states have pretty good governments. Maybe it's just not as corrupt as what you're saying. Let's see. Texas, this is for you especially. So, doing a little bit of research, I ran across this article talking about in California from 1997 to 2009, there were 707 instances where a judge found that a prosecutor committed misconduct. Not somebody writing in a bar complaint, not somebody who doesn't know law, not somebody who's just upset with what happened to them in a courtroom. A judge found that prosecutors were committing misconduct. Let's see what happens. Only 6 of those, less than 1%, resulted in a public sanction by the state bar. Less than 1%. A judge. In Massachusetts, as of April 2016, only 2 prosecutors had been publicly disciplined since 1980. Despite at least 142 instances over the same time, that period where a judge reversed a guilty verdict or dismissed charges based on a prosecutor's misconduct. That's strange. So, there's this Harvard law professor. I believe you know him. His name's Alan Dershowitz. I believe he was one of Jeffrey Epstein's attorneys and maybe Bill Clinton's attorney. I don't know. Just maybe. Anyways, he is a Harvard law professor. Here's what he has to say. Prosecutorial abuse is rampant. Why is it rampant? Due to the lack of a uniform reporting body, each state has its own attorney disciplinary system. That's interesting. In a 2003 report by the Center for Public Integrity, a nonprofit governmental watchdog group examined more than 11,400 allegations of prosecutorial misconduct in appellate court rulings between 1970 and 2003. In 2012 of those cases, 17.6% misconduct by prosecutors led to dismissals. Not dismissing the prosecutors, but dismissing the cases. However, only 44 prosecutors faced disciplinary actions, and 7 of those actions for discipline were dismissed. According to the Center for Prosecutorial Integrity, studies over the past 50 years, including some of those cited above, indicate that in 3,625 identified cases of prosecutorial misconduct, public sanctions were imposed in only 63 cases, less than 2% of the time. And of that discipline, just 14 prosecutors were suspended or disbarred. Only 14, and that's suspended or disbarred. I bet of that 14, the disbarment was just one Mr. Nifong. Mike Nifong was probably the only prosecutor to get disbarred. Everybody else just got suspended, but suspended with a stay like they did for Greg Newman. Alright, as far back as 1908, when the American Bar Association adopted its canons of professional ethics, prosecutors have been instructed that the primary duty of a lawyer engaged in public prosecution is not to convict, but see that justice is done. This is actually what Greg Newman said about why he let James Sapp off. Was because he had to protect James Sapp's rights to justice. You see what I mean by they know what the law is when they want to use it against you? But when you want to use it for some strange reason, they kind of, where'd the law go? What happened? Where's the law? Is it under this rock? Where was I? The suppression of facts or secreting of witnesses capable of establishing the innocence of the accused is highly reprehensible. It's highly reprehensible. It should be criminal. But just because it's not illegal doesn't mean it isn't criminal. You know, slavery was legal at one point in time. The Holocaust was legal at one point in time, so segregation. Legal isn't the best way to set your morals or ethics. 27 years after the canons were adopted by the United States Supreme Court, and Mooney versus Holohan was forced to inform prosecutors, so the Supreme Court was forced to inform prosecutors that the knowing use of perjured testimony to convict a criminal defendant violated due process of law. You think? I am going to use what I know is perjured testimony to make sure I get this conviction. Yeah, I'm not even an attorney, and I could tell you that that was a due process of law violation. I think anybody with common sense would know that that's a due process violation. I mean, even in the time of Moses, it said something like, "Thou shalt not bear false witness." I think even back then people knew that that was a outside of the justice of law. This is funny. Kind of. Okay, so Professor Gresham, writing South Texas Law Review, summed up this disturbing problem as follows. So, this is a professor of law writing a law review for South Texas, and here's what he says. Making prosecutors accountable for violations of Brady has not been a success. Okay, so a Brady violation is basically what they did to Mike Nifong. They said that he was withholding DNA evidence that was exculpatory to their clients, to, the defendants, and that's why they disbarred him. Even though he couldn't have really technically withheld it because they never really went to trial and he handed it all over, which is how they kind of found out that, at least two of the boys were really innocent. And that's why Mike Nifong dropped the rape charges. So I don't see how he actually withheld it. Anyways, whatever. That's neither here nor there. To be sure, bar associations and grievance committees have the power to discipline prosecutors for violations of ethical rules. However, most commentators agree that professional discipline of prosecutors is extremely rare. So what he's saying here is that the bar associations and these committees, like the committee that Greg Newman went before, they have the power to disbar prosecutors. They have the power to hold them accountable. They just don't for some reason. And where did they get this power? Because I can tell you 150 years ago they didn't have it. I can tell you that for a fact. But we're going to get to that here in a minute. I'm just giving you like a precursor of what's coming up. Okay, this comes out of Texas District and County Attorney Association. And they're going to tell you how good they are now. Because, well, they only care about the public's perception. And I guess 5 years before this was written, the public's perception of prosecutorial misconduct was really, really bad. So they wrote this article, to get your perception to be better. So that maybe you would trust the legal system again. Anyway, I don't know. During its research phase, the committee spent quite a bit of time discussing accountability for wrongdoing. One narrative floating out there for 5 years ago was that Texas prosecutors were not held accountable for their conduct. This was a tough area to delve into because it meant doing something uncomfortable. Talking about the past missteps and misconduct of Texas prosecutors. They're uncomfortable just talking about it. Maybe that's why they're they're just too uncomfortable to do anything about it. I mean, this is silly. And why are you uncomfortable talking about it? Is it because you know that there's a rampant problem and it's actually your job to do something about it? So yeah, I would be pretty uncomfortable telling, my bosses, I guess the public's not really their bosses because these positions are typically appointed and obviously they're unaccountable. But they're supposed to be doing a job for the people. So yeah, I would feel uncomfortable telling my employers that I'm not doing the job that they expect me to do, but I wish to be paid anyways. Or, while you're at it, maybe give me a raise, give me a promotion, Come on. That's how this game seems to work. Now, when we come down to accountability, nonetheless, the committee researched the topic and discovered that there is indeed plenty of accountability for Texas prosecutors, from state bar discipline and criminal investigation to removal from office and courts of inquiry. See, here's the thing is, there's plenty of ways that they could be disciplined. But the question is are they? Are they? So I started trying to look up, hey, how many Texas prosecutors have been disciplined, disbarred, doing something awful, breaking some laws, being criminals. Well, just because it's Texas. There was this one time in 2016 where a prosecutor got arrested for a DUI and brought an indictment over the governor.
Powerful Democratic district attorney in Austin was charged with drunk driving more than a year ago, and her behavior was caught on camera. It shows the most powerful district attorney in Texas, Rosemary Lemberg, drunk and abusive as she's booked for drunk driving. The move is why Perry now is facing 2 felony charges. A prosecutor and now grand jury say he illegally tried to coerce Lemberg, a Democrat, to quit.
Yeah, that's pretty crazy. Oh, and then I was trying to look up cases where federal prosecutors or Texas prosecutors were being held accountable. Because, this was 2018. So I found this case. I found this in Legal Prison News. September 25th, 2017, the State Bar of Texas filed a disciplinary action against former Harris County Assistant District Attorney Elizabeth A. Exley. She is accused of striking deals with 3 jailhouse informants in exchange for damaging testimony against Edward George McGregor, without notifying his lawyer in the 2010 capital case. So this is a case that somebody could be put to death for. She goes and gets 3 jailhouse informants to testify against him. She doesn't inform his attorneys. And I think it's crazy to have jailhouse informants anyways because they don't have firsthand information of the facts. The only thing that they could testify to would be what he said. And what he said, he's there in the courtroom. Obviously, he's not going to admit that he said it, which makes it undeniably hearsay. And they could just make it up. And they would have a motive for making it up because, well, the prosecutor's going to go real lenient on them if they do. Additionally, she failed to correct the informants when they lied under oath at trial regarding critical aspects of their testimony, including whether they were testifying in exchange for leniency or other favorable treatment. Based largely on their own perjured testimony, McGregor was convicted and sentenced to life in prison. So they committed perjury. The prosecutor knew about it, didn't do anything. Let's see what happens. Obviously, they're going to punish her, right? We just saw how, what does it say? It says, There's plenty of accountability for Texas prosecutors, from state bar discipline and criminal investigations to removal from office and courts of inquiry. So, of course, you know me. I got the bar documents right here. They made those public. We'll get into that in just a minute. Agreed judgment of probated suspension. That sounds pretty serious. At least there's a judgment. Jurisdiction and venue. Pursuant to Rule 3.02 of the Texas Rules of Disciplinary Procedure, the Supreme Court of Texas appointed the Honorable Ronald Rangel to preside over this disciplinary action. The court finds it has jurisdiction over the parties and subject matter of this action, and that venue is proper. So this actually kind of threw me for a loop for a second, because this is an administrative court, which means that the legislature had to give it the jurisdiction to administrate this particular subject matter. And if you remember, they really spell it out in Greg Newman's case. Because right here, the thing that the Bar Association is presenting is that Greg Newman is a defendant. He was admitted to the bar, and the proceeding under the authority granted it in Chapter 84 of the North Carolina statutes, general statutes, and the rules and regulations. So the North Carolina general statutes, the state legislature gave them the jurisdiction to move this into administration. So, you know me. If I got a question, I'm going to answer it. It's Chapter 81 State Bar of the Texas compiled statutes. I don't know what they actually called it. You go to Section 81.033, Open Records. And this is really, really important, okay? Like, incredibly important. All records of the State Bar, except for records pertaining to grievances that are confidential under the Texas Rules of Disciplinary Procedure, are subject to Chapter 552, which is obviously about the government being open and you can go and get the records and all of that. So, but what this is telling you is that if the Bar Association doesn't bring an action on a grievance, nobody can ever find out about it. It's confidential. You can't talk about it. So we don't know how many actions get filed, how many complaints get filed with the State Bar Association. And they are a public corporation. They're not a government agency. They're a public corporation. Section 81.071, whatever that means, disciplinary jurisdiction. Each attorney admitted to practice in this state, and each attorney specially admitted by a court of the state for a particular proceeding is subject to the disciplinary and disability jurisdiction of the Supreme Court and the Commission for Lawyer Discipline, a committee of the State Bar. This is where the state legislature of Texas handed over to the Bar Association, a public corporation, the jurisdiction to judge and handle its own bar holding member associates. And every single state has done this in one way or another. All of them. And that's why Alan Dershowitz was talking about there's no uniform way to hold these people accountable. And you want to know what the uniform way used to be? You want to know how it used to work out, because they're under the executive branch and you used to not be able to vote on the executive branch. We've been talking about that on Make Athens Great Again. But here's how they used to get held accountable. We talked about that before. It's called a grand jury. See, all these executive branch agencies that are running around, they used to have grand jury members sitting on top of them. And if they saw anything suspicious, they would go to the other members of the grand jury and present to see if they got an indictment. Don't you think that would make government actors shape up really quick? Anyways, that's how they got jurisdiction. So let's see what happened. Here is the findings of facts. The findings of facts is she's an attorney. And here's where she practices. And she was a special prosecutor. And in 2010, respondent failed to disclose to the defense her willingness to give favorable sentencing recommendations on behalf of 2 testifying witnesses with pending criminal charges based on their cooperation during the murder trial. Now that's funny because the news said it was 3. And the news also said that she knew they were committing perjury. Just like the Bar Association knew that Greg Newman was committing perjury. Knew he violated his oath of office to the Constitution. But that doesn't apply to them. I'll tell you in just a minute with their own words. So their conclusion of law is that the respondent is held liable for 3.09D, whatever that is. I'm not going to look that up because it's as much nonsense as 3.09D. Hey, we're going to let this rapist go for 3.09D, okay? There's your justice. All right, the terms of the probation. This is all pretty silly, but just look at number 3. Number 3 is a pretty big number. Respondent shall not violate any state or federal criminal statutes. That's really interesting. That's the same thing they said to Greg Newman when they suspended his bar license with a stay. And the whole thing about probated suspension, see, these are the terms of her probation. The terms of her probation, she can keep practicing law, but the terms of her probation is that she's supposed to follow the statutes. What does that tell you? That tells you that she didn't have to follow the statutes before. Just like Greg Newman didn't have to follow the statutes before. And you want to know how I can prove that they didn't have to follow the statutes before? Is because it was known that she withheld this information and that the people she put on the stand committed perjury. Because they committed perjury and she knew about it, and she's a state prosecutor, and I would bet dimes to dollars that she instructed them on how to testify. Because I've never known somebody get up on the stand that hasn't been instructed by an attorney. Never. Anyways, that news article said that she knew from the facts that we got from here. We can say that she knew. I mean, it wasn't disclosed at trial. That is called subornation perjury. In Texas, it's aggravated perjury. It's a felony. It's a crime. And that criminal statute did not apply to her because she was an attorney. She was an attorney. Anybody remember that show to catch a predator? It was on for a couple of years, and they'd set people up with children online, and then when the predator showed up, they'd come out and be like, hey, what are you doing here? You know how that show ended? They caught a Texas prosecutor, and when they went to execute the warrant, he shot himself. Anyways, like, share, subscribe. If you wish to meet up in Tennessee, let's talk about it. Email. I am just conspiracy, and I just wish to conspire with other good people of this planet to leave a better world for future generations, for my little man in training, than the world we all grew up in, because this is bunk. Love ya all. Peace.
He's been chatting on the phone with an actor hired by Dateline and online with a decoy from Perverted Justice. And there's little doubt about what's on his mind.
He sent penis pictures.
Frag from Perverted Justice alerts police.
He got pretty sexual on the phone and it's recorded. We're chatting with him right now.
I'd like to if you let me.
The phone number he gave us traced to his home phone.
Using the screen name InExcess00, the 56-year-old chats with a boy who says he's 13. The prosecutor pretends to be a 19-year-old college student, sending these pictures of a young man who looks like a model. The decoy acts suspicious.
You're hot and in college. You can get all the guys you want. Why me?
To me, you're hot.
Why?
I like younger.
Really? Like for boyfriend or just sex?
Both. Later, the prosecutor sends pornography to the decoy.
Is that your...
Yes.
It looks huge.
Please don't trade it, Luke, okay?
No, I swear.
The chat continues on and off for 2 weeks. The assistant district attorney, in excess 00, asks the decoy if he likes to kiss and cuddle. The decoy asks what he means. In excess 00 responds, holding each other, feeling all over. Later, the prosecutor says he'd love to see the boy masturbate.
So when do you want to come over?
Eventually, they talk about meeting in person.
You could bring some condoms. Maybe you could bring some beer.
But Conrad never shows
He
up.
was Bill Conrad, a former Kaufman County DA, at that time an assistant Rockwall County District Attorney. He was to be To Catch a Predator's last and most notorious Murphy target. Patricia Conrad is his sister.
And these people were acting as not only police, but judge, jury, and executioner. If you have a suspect who's not responding, do you storm his house?
The officers force their way in. For almost 5 minutes, we don't see or hear anything. Then Lieutenant Adana Barber of the Murphy Police Department comes out and tells us what happened.
As they made entry, they confronted the suspect. I believe he was in the hallway, and he told them he wasn't going to hurt them, and then shot himself in the head.
And he had a pistol in his hand.
Small caliber.
It was a devastating tragedy, a shock to all of us when the 56-year-old, a man who has prosecuted criminals for more than 2 decades, shot himself.